Hello students, welcome to Legacy IAS Academy. In today's video, we are going to address a question that has been asked by the President of India, Droupadi Murmu, to the Supreme Court regarding the power that is given by the Constitution to both the President of India as well as the Governor of India and the recent interpretation of Supreme Court in this particular regard. So let us try to understand this in more detail. Now we know that in the earlier month of April, Supreme Court has set a definite timeline for the president and governor to act on the bills. For president, those bills which have been reserved for the consideration of president by the governor of any particular state, and for the governors, the bill that is referred to him by the state legislative assembly or a state legislative council as such. So taking consideration of these changes or this interpretation, now President Droupadi Murmu has sought the opinion of the Supreme Court under the Article 143. Now, in the Constitution of India, under Article 143, empowers the President to seek the opinion of the top court, that is the Supreme Court, in the matters related to public, what you can call as the public matters. Now, whether their actions, what basically we talk about, we'll discuss later what are the questions and the set of questions that have been forwarded by the president. Let us try to understand what largely the questions are asking for. So, first question is that whether the actions of both the president as well as the governors of the states of India are justiciable in nature. Justiciable here is a very important term. So, justiciable, when you talk about the term, it basically means that whether the action taken by president or the governor in the discharge of their duties and the powers conferred to them by the Constitution of India, can that be questioned? Can they be questioned in the court of law? Can decision be taken on them on the basis of the legal principle by the court or not? That is what we mean by justiciable. So indirectly, what is being asked from Supreme Court is whether the actions taken by the president and governor can be decided and can be studied in the court of law. Second, whether such timelines can be imposed on them. As I told you, the Supreme Court has said that you have a definite timeline within which you have to clear your overall decision on a particular bill as such. So, can such timelines be imposed on them? Because the reason why this question is asked, as per the Constitution of India, there is no provision of a set deadline or timeline with which president or governor have to assent to the bill as such. That is why the question has been raised. Now, if you try to understand about the background, we know that in the month of April, the Supreme Court of India has clearly stated that if a bill is reserved by the governor for the consideration of president, the president must decide and clear his or her position within the 3 months of receiving the bill. If there is any delay beyond it, that means president cannot just use absolute veto. President cannot use the overarching executive power that is vested in the office. Rather, the president's office will have to convey the region to the state concerned, the state that has forwarded the bill, that why there is a delay over the decision on the bill. Now, also the Supreme Court has stated here that we prescribe that the president is required to take a decision on the bills reserved for his consideration by the governor within a period of 3 months. So, 3 months, that is 90-day period, has been clearly stated by the Supreme Court as such. Now, apart from talking about the president's deadline for the president, it has also taken a stance on the governor's power. For example, Supreme Court has clearly stated in the verdict that was taken in the case of Tamil Nadu Governor R.N. Ravi that the constitutional role of the governors must be to act on the advice of Council of Ministers as such, as they do not have discretionary power under Article 200. What is under Article 200? We are going to discuss in the later part of the video. Governor cannot be vested with such a power which would enable him to collude the Union Cabinet. Now, see, this is a very important point that has been made by the Supreme Court, because generally, if we talk about the powers of governor in the state, when any particular bill is passed by the state legislative assembly or a state legislative council, in few of the states we have a legislative council as well, in that case, finally after the passage from the house, the bill is forwarded to the governor. Now, governor has 3 possibilities or 3 3 different actions he can take. Either he can give assent to the bill, or he can withhold assent to the bill, or he can reserve the bill for the consideration of the president as such. So, while doing so, Supreme Court has clarified that governor should not collude with the union cabinet or the central government largely, because if you try to understand practically, governor can be considered as the representative of the central government in the state as such. So, he should not collude with the union cabinet and ensure the death of any and all legislation initiated by the state. because legislation or act cannot become law unless and until it receives the assent from the governor. That means practically governor can withhold all the bills that is being passed by the state legislative assembly, and that means it will be a death for all kind of bills. That is what Supreme Court has raised the point in this particular regard. So when you talk about the Article 201, what is the Article 201 that is being referred here? If you talk about the Article 201 of the Constitution, it clearly states that when a bill is reserved by the governor for the consideration of the president shall declare either that he assents to the bill, again same three things, or that he withhold assent therefrom. He cannot just be sitting on the bill without conveying his position that whether he is assenting the bill or not for an indefinite period of time. Now, this is something is not which is provided in the Constitution that within what time frame president has to make his mind about a particular bill as such. And this is something that Supreme Court is trying to put a timeline of 3 months in this particular regard. The question that is being raised in this context by the President Droupadi Murmu to the Supreme Court is that is the exercise of constitutional discretion, because this power of president to withhold the assent to the bill can be considered as discretionary power under the president under the Article 200 on the Constitution in India is justiciable in nature. Again, justiciable means can it be questioned in the court of law or not. Second is the exercise of the constitutional discretion by the governor, because you know that in the state similar kind of power has been given to the governor also. So under the Article 200 of the Constitution, can the decision taken by governor to withhold the assent to the bill can be questioned in the court of law? These are the first two set of the questions. Apart from that, also the question is raised about the definite timeline that has been given by the Supreme Court, because as we have discussed in the Constitution, you do not have any prescribed timelines, and the way how president and governors have to exercise this power under Article 200 or 201 as such. So that is what the question is being asked, that can timelines be imposed and the manner of exercises be prescribed through judicial orders. Now this is very, very important point, because if we talk about any democratic setup, including India, you have three different wings of the government. You have judiciary, you have executive, and you have legislature. Now, when we talk about the Constitution of India, the judiciary has been given the power to interpret the Constitution and to declare any particular kind of what you can say, give any particular kind of ruling or any particular kind of directive based on the interpretation of those Constitution. But as far as kind of bringing any change in the Constitution is concerned, amendment to the Constitution is concerned, that largely is the domain of legislature. So basically, as I told you, in the Constitution of India, there is no set timeline in which president or governor has to take the decision. And Supreme Court has said that now you'll have to follow the timeline of 3 months as such. And this is in which, and it is in this regard where the president has asked the question, can judicial orders be used to put such kind of timelines for the exercise of discretion of power either by the president or governor of India as such. Now we talk about the governor's power. Other question is that is Article 361 of the Constitution of India. Now what is Article 361 of the Constitution? It is basically an exception to Article 14. We know that Article 14 provides right to equality to all the citizens of India. So under Article 361 of the Constitution, it clearly states that the president or the governor is not answerable to any court for the exercise of his powers and duties of his office. And under Article 200 and 201, that is where the power is being exercised here. So that is what the question is being asked Supreme Court, that is Article 361 of the Constitution of India an absolute bar to the judicial review in the relation to the actions of governor under Article 200 of the Constitution of India or not? Because when you talk about judicial review, it is basically a type of check and balance you can understand. I told you that in a democratic setup, you have judiciary, you have executive, and you have legislature. So whenever you see the legislative branch or the executive branches of government, whenever they exceed their authority, judicial review kicks in. Judiciary can take them to task and can declare their decisions and can declare the actions of legislature and executive as a kind of ultra vires. So that is what question is being asked here, that Article 361 that gives power to the president and governor that they are not answerable to any court of the law, can that be barred by the what you can call as under the Article 200 of the Constitution of India, and judicial review, can it be applied in those cases? So that is the other question, the third question we can say. Apart from this, next one we have is the recommendation that SC has given, that in light of the constitutional scheme governing the powers of the president, is the president required to seek advice of the Supreme Court by way of reference under Article 143 of the Constitution? Because I told you that it is again discretionary power of the president, that whenever the president office understand or feels that there is a need to get the guidance from Supreme Court in the matters of public importance, they can seek the guidance. But the question is being asked, that the president required to seek advice of Supreme Court and take the opinion of Supreme Court whenever governor reserves a bill for the president's assent or otherwise, or whether president is free to use his or her own intellect and mind to come to a decision about the withholding or giving assent to the bill. Second question, similar kind of question has been raised about the governor also, that is under Article 200 and 200 of the Constitution. And second point that is raised here is that whether that we can say that you talk about the decisions taken by either the governor or president under the Article 200 or Article 201 of the Constitution, both we have discussed earlier. The question is being asked that whether this decision can be questioned even before the law has come into force, because again, if you try to understand, bill is passed by house, it is forwarded to the president or the governor based on whether it is union parliament or the state legislative assembly, then it receives assent, then it becomes law. So before the bill has become law, before the act has become law, the decision taken by president and the governors in this regard, can it be questioned in the court of law? Next question is it permissible for the courts to undertake judicial adjudication over the contents of bill in any manner before it becomes law? That means, can the Supreme Court or any court adjudicate, that means try to decipher and look into the matters and the content of the bill before it has become the law? Then, can the exercise of constitutional powers and the orders of or by the president governor be substituted in any other manner under Article 142 of the Constitution of India? Again, Article 142 is a very, very important article. It provides Supreme Court the right that it can pass any decree and order to ensure complete justice in any matter pending before it. So that is what the question is being asked. Can the exercise of constitutional powers and the orders of the president or governor be substituted in any manner under Article 142? For example, whatever decisions president or the governor's office has taken, can Supreme Court reverse it? Can Supreme Court question it by using Article 142 or not? That is what the question that has been raised here. Then if we talk about the discretionary power, what are the constitutional options before a governor when a bill is presented to him under Article 200 of the Constitution of India? Is the governor bound by the aid and advice tendered by the Council of Ministers? Because as we know that the Supreme Court has taken this stance that governor has to always act on the aid and advice of the Council of Ministers. Now, when a bill that is passed in the state legislative assembly, when it is passed to the governor, as I told you that under Constitution he has three different options. He can withhold the assent, he can provide the assent, or he can reserve the bill for the consideration of the president as such. So that is where the question is being asked, that what are the options available with him when a bill is presented before him under Article 200 of the Constitution of India? Because if he has always abide to the aid and advice of Council of Ministers, then most of time or in majority of cases he will have no other option but to give assent to the bill itself, because the Council of Ministers, as we have discussed, is responsible to the Lok Sabha at the center and to the Legislative Assembly at the state government level. So that is the other point. Then what you can say in conclusion, if you look at the interpretation of Supreme Court in the early April regarding the power vested by the in the office of President and Governor under Article 200 201, it seems that the SC has interpreted it to enhance the accountability and reduce the arbitrary delays, because Supreme Court also clearly has stated that if there is an undue delay without any valid reason by the president and governor to provide assent to a particular bill, it is amounting to arbitrariness or exercise of arbitrary power as such. So this decision strengthens the federal governance by empowering the states to challenge undue delay, because if suppose till 3 months if president has not taken any decision regarding the bill, then a state will have the right to question that why there is no decision coming from the president's office, and that will ensure that the federal nature of our governance, federal nature of our polity is strengthened as such. Also, it ensures transparency and safeguard against the misuse of executive power in the legislative process as such. So it is with this intention and regard, Supreme Court has interpreted and has put 3-month deadline for presidents in the case of Article 200 and 201. So questions, these are some of the questions that has been raised by the President Office. We have to wait and watch and see how Supreme Court responds to all this question, how they try to answer it and give their opinion on the matters of public importance and legal importance and such. That is all about this particular video. If you like the video, please hit like button, share it with fellow aspirants, and subscribe to our channel for more such content. Thank you very much.